All right, great. Thank you guys so very much for being here. We have a very robust agenda, so I will not waste your time with my eloquent tenor. To start us off, I think the voices everyone is waiting to hear is associated with the additions as well as the approval of the minutes and the administrator's report. Okay, so moving on, declaration of quorum has been declared. Any additions to the agenda at this time? Noting that there is none, moving on to the approval of the minutes for June. Now, I understand that two of our present members were not a part of the June meeting. So that would be mainly looking at Vice Chair and Jake. Is there a motion to approve the minutes?
Mr. Chairman, just a quick thing, not to be nitpicky, but for the June 20th minutes, my last name is spelled wrong, and I'd love to just get that corrected. But otherwise, with that correction, I'd like to move to approve the June 20th and July 27th minutes.
Is there a second?
Seconded.
All those in favor, raise your hand. Well, seeing that,
Mr. Chair, I think we'll need four. So we'll need,
even
though they weren't there, we'll need Carlos or Janet to vote.
Duly recognized. Thank you. Seeing we have approved the minutes with the corrections of the spelling of Mr. Weissman's name. It is so approved. Moving on, looking at the approval of the minutes for July 27th, is there a motion to approve those or any updates?
I'd like to motion to approve July 27th minutes.
Seconded.
Second is properly seconded by Vice Chair. Jake, is your name spelled correctly in that?
It is.
Okay, great. All right.
I think your first name is misspelled.
I was, really? I missed that.
I noticed that. I apologize for that.
Okay, so we will update that record. Duly recognized. Appreciate that, Jared. With it being properly seconded by the Vice Chair, is there all in favor? Show you by raising your hand. All right, we have a unanimous vote and to approve the minutes for July. Thank you. And with that, moving on with the administrative report.
I think before we move on, David, can you just double check to see if the video is working? I received a social media message that it was not functioning.
We're streaming.
I see it on.
Okay, good. Just wanted to double check. So.
All right. Also, duly recognized. I do not see the state administrator, Linda Lamont, present. With that being said, the administrator's report will be delivered by Jared Demarinis.
Yes.
And thank you so very much for being present for us to move forward. It is your floor.
Thank you, Chair. So I'm just going to go through the administrator's report and welcome any questions along the line there. But first, we wanted to just there was a lot of farewells that I wanted to announce and make sure that, for everyone. Shafiq Satterfield will be leaving SBE. He's going to become the IT director over at Prince George's County Board of Elections. He had joined back in 2013 as a regional manager. He served as a lead regional manager and now was the director of IT project procurement and also is the project manager for the new e-poll book solution. So this is a big loss for SBE, but we are happy that he still is in the elections community and will be always relied upon. Diane, so there's always a silver lining in everything. Diane Zagorski is also leaving the state board. She is returning back to Howard County as a county legislative auditor. She was the audit manager for the Candidacy and Campaign Finance Division. I worked closely with her, and she is, I wish her well in her new position in Howard County. Now, some of the bigger ones as well. Donna Duncan, on October 1st, will retire after more than 45 years of service. Basically, she has been with the State Board of Elections in almost every iteration that it has ever been a part of. And she has served her entire career and countless hours serving Maryland's voters and election officials. And she is a historian of the most random facts about elections and outliers that have occurred in the state. And she has long deserved this, and much kudos for her retirement here after 45 years of service. On August 23rd, Nikki Charleston left SBE to become the Deputy Administrator of Central Operations for the MVA. She began her career basically with SBE in 2003, and then has served as the Deputy Administrator since 2013. She has, served the voters well and SBE, and she has been a quality person, and I wish her the best of luck in her new position, and just in all that she can do with MVA. And she'll probably still be a part of elections because we do interact with MVA as an AVR agency as well. So, and then on August 31st, Linda Lamone will, of course, retire as the State Administrator of Elections. As you know, she has been, since 1997, and has, maximized the use of technology. She, prior to this, also served as the Assistant Attorney General, representing the state in the Board of Elections. And so, she's been at this office for 25 years, and I believe, recently received some accolades from NASHED, which is the National Organization of Election Directors. So, those are all the big news that is going on here, that is leaving and moving forward with it. Like I said, Linda has basically, seen it all from, Help America Vote Act to, COVID and just moving forward. So they've been, for 25 years, Maryland's voters have been in her hands. It's been fantastic, fantastic base to build off of for me. And then on some positive, also on some, I guess, a different note here, Tyler Carr has joined SBE starting on August 8th. He is the Director of Election Policy Projects, and he is going to work with the Policy Division to manage data-related projects at SBE. He comes from the Maryland State Education Association, where he served as the Managing Director for our data and membership operations. And he is eager to work with the divisions and help with the polling place plan, which is House Bill 410, the implementation of that for the 2024 elections. Tyler, are you on the line, or? Oh, I guess not. So but welcome, Tyler, to SBE. We had the summer conference of NASHED was in Charleston, South Carolina. The focus was on disaster preparedness, tabletop exercises, and of course, serving military and overseas voters. Linda attended the conference and was honored with the first Elaine Manlove Award for Distinguished Service, and we have attached the press release there. We had an election directors meeting on July 20th and August 17th. We updated the local boards on various projects, but most notably the electronic poll book project and election prepared tasks. We have included summaries of both of them in the county bulletin for you as well. And now, I guess I can turn this over to Mary Ann, if you want to talk about election reform and management.
Okay, good afternoon. Thank you, Jared.
Thank you.
Just want to echo best wishes to those leaving us, particularly Linda, Nikki, and Donna, who I've learned so much over the years from, especially since joining SBE just about a year and a half ago. Welcome to our new board members. I haven't seen you, or we haven't seen each other yet. So welcome, and also to our returning members. I look forward to a successful 2024 election cycle. I don't really have anything to add to the report. There are links provided to the EAC's comprehensive report, as well as our 2022 elections webpage. Those contain the data that we submitted on a variety of election topics from 2022. We created Post to recognize National Poll Workers Recruitment Day on August 23rd. Thank you. So we've had a little uptick in activity, not tremendous, but we're going to be really working hard on that for 2024. We did great in 2022, and I expect the same for 2024. I also wanted to highlight that some boards hosted events to thank their judges, like Baltimore County. They had like a meet and greet where they offered light refreshments. And I think it's great. It's a really nice way to show their appreciation to them, but also keeping those judges involved and engaged. So that was wonderful. The online training has been overhauled. I will have a new look and feel. I'm really excited about it. I am, because I've done so much with training for about 20 years. It's nice to have a fresh take. So yeah, I'm just really happy about it. And I think the judges will really appreciate it. So we've been reviewing the modules and turning towards the styling reporting now, and it's scheduled to be released in October. Does anyone have any questions for me?
Jake, you're recognized.
Thank you, Mr. Chair. Thank you for that, and kudos on the social media and the recruitment. Just a quick question. Are we able to get a sense as to what that training looks like, since it's new and revised? That sounds really exciting.
So we're still in draft form right now. As soon as we get it a little more polished with the we can see about setting you up so you can take a look at it.
Awesome. Appreciate it.
Sure.
All right, great. Are there any other questions? All right, Jared.
Okay, now we're on to voter registration. Brett, if you wanted to handle that section there.
Thank you very much, Jared. And I will echo Mary Ann in saying that it's bittersweet to have all this knowledge and expertise walk out the door, but very appreciative for the time that I did get to spend with everybody and pick their brains as I came on board. So we'll be missed, but know that the knowledge that you bestowed upon us will continue. So nothing to add from the report, but I just wanted to highlight a few items. We did complete our 9.2 release of MB voters at the end of July. This particular release focused heavily on candidacy and campaign finance and the modules that we utilize within that system. And it also gave us some new list maintenance to do based upon some AOC and MDH data, where we're taking a deeper dive into making more detailed matches into trying to identify possible duplicate voters within our system. Second thing I wanted to highlight is the surrendered license mailer that went out at the end of June this year. We sent this mailing out to about 14,000 individuals who MBA gave us data that they had surrendered their license to an out-of-state authority. The responses have been trickling in. We've already performed 560 cancellations from those responses that we've received. We imagine that this is going to take several months for all the responses to either come in via USPS or the actual individuals who are responding. But so far, so good in getting some good confirmation on cancellation data from this particular mailing. And lastly, just wanted to highlight that we are in the midst of our ERIC VPP process. This is the voter participation project that focuses on possible duplicate voting, both within the state of Maryland and cross-state with other states. We are currently scheduling our cross-state evaluations with those other states where Eric has identified possible individuals that may have voted in both states, and we'll be conducting those meetings to see if further investigation is warranted. Are there any questions for me?
Mr. Chair. Mr. Chair?
Yes, the chair recognizes Vice Chair Ball.
Brett, I am so happy to hear about the surrendered license thing. It's something we've been working on for a few years. It was something that we started out, and I just thank you. Kudos to you for getting it through to the finish line. It was started a while ago. We had some hiccups along the way, and it just makes me smile to know that we're getting that done. Thank you for your work on that, and thank you to the staff before you who kind of got through some of the hiccups as well. So thank you, and glad to hear that. I would wonder if you could maybe report back next time this thing, the Eric potential duplicate voters, if you could let us know what those numbers look like in the next meeting, that would be appreciated. Thank you.
Bill,
for your work.
Yeah, absolutely, Bill. I do have an estimate on it. It's actually fairly low this year, as I've been told, in comparison with past years. There were less than 200 individuals found across all three reports, in-state, deceased, and cross-state. But yes, I will absolutely report on that next meeting.
Thank you so much. Again, appreciate you.
You bet, Bill.
Thank you, Vice Chair. The chair recognizes Jake.
Thank you, Mr. Chair. Mr. Paradise, just a couple questions here as I was going through this. Number one, curious, what information are we currently getting from AOC and MDH?
So, Mr. Weissman, it's no different than the information we're previously receiving. What we're doing, though, is we're taking a deeper dive into any non-matches that we are not able to find with MD voters. And what we're doing is performing some fuzzy matches on those non-matches. So the report creation was simply to get a report specifically of those that were not matching the system automatically previously.
I just want to make note of that. We are changing the reports that were, one of the departmental bills is to help get better data from AOC in this situation, which we'll explain a little bit later in the departmental portion of it. So it kind of ties in what Brett is doing now, and then we're going to get even cleaner data to help with the rolls.
Fantastic. And then my next question, I don't know if this is for Mr. Paradise or Mr. Demarinis as the incoming administrator, so forgive me, was wondering, in these reports every month, we get the MVA transactions. I'm wondering if we could get a chart comparing month to month, as well as this time this year to this time last year to the year before. I think, at least for myself, I'm a bit of a visual learner, and being able to see that can help better understand the patterns.
Yeah, I don't think that would be too difficult to put together whatsoever. So yes, I absolutely look into that with my team. But yeah, I believe that'd be something we could add fairly easily to the report.
Appreciate it. Thank you.
All right, the chair recognizes Janet. Thank you very much for that, Jake. Janet, you have the floor. If you're talking, we can't hear you.
Okay.
There you
I'm not quite clear. If somebody moves, say, from Frederick County to Anne Arundel County, what's the process for that kind of address change? They didn't move out of state, but they will need a new driver's license with a new address. How does that go through the system? How is that tabulated?
So once the person moves in state and then applies for a new driver's license at that particular address, we would receive the MVA data automatically, and then it would be utilized to update.
Okay.
All right, thank you all very much. Moving on, are we at the candidacy and Jarrett, go ahead.
Yeah. So right now we have 33 candidates that have completed to be filed at SBE. But we expect the uptick as it gets, now that, past Labor Day, more and more candidates will be coming in and filing for the 24 election. I gave some statistics for website activity there. I don't have to necessarily go through it. And then all the enforcement actions from June and July are for you as well. We have been vigilant in making sure that the 48-hour reports and making sure that independent expenditure entities have make sure that they file timely and working in the future with that. So this has been basically a boom on that one there. We had a big fine, of course, of $10,000. And just when we're going through these audits, making sure that the candidates or the political committees that have some, I'd say, discrepancies, that when we do a more deep dive in the audit, we're finding that there's a failure to maintain some campaign records here, and that's where all those fines were coming up with as well, though with civil penalties on that front there. So that's kind of it on the candidacy and campaign finance side there. If there's any questions, I'd be happy to answer them. If not, then I'll go to the new poll book solution.
Chair recognizes Jake.
Swear I won't have a question on anything. And Mr. Demarinis, this isn't necessarily related to campaign finance and candidacy, but I noticed you've got the website statistics in this report, which is really helpful and educational. And wondering if it will be possible in a future meeting to get the website statistics for the state board website at large. I think it could be really instrumental to know which pages are being looked at most frequently and things along that line.
Okay, again, I'm not sure if which ones are getting in there, but I can give you charts of if it's superficial or something like that. I can give you. I can work with you about what the status is on or how deep we got, but not a problem.
Thanks.
No. All right. Next up is the new poll book solution. As you know, that this was supposed to be for the use for the 2024 election, and we have a procurement that is going out there, and we purchased the solution. It is in a current no-go state for the 2024 election at this time. The vendor has failed to deliver a minimum viable product suitable for use in a Maryland election. And we just received the final release that was from last Friday on the 25th. And now we're in the 2-week testing period to make sure that they had met the minimum viable product standards. And at that point there, after the 2-week period of testing, I'm going to make a final determination as to go, no go on the new poll book solution. And we will be using all the stakeholders, including the test and evaluation teams, but also including the local Board of Elections subcommittee as well in that the final decision. There is contingency plan should there be a no-go decision, and that is to use the existing poll books for the 2024 election. And there will be needs for some contract extensions and other procurements with that. So we would have to go in front of the Board of Public Works but we're making sure that we are going through every possible scenario here and making that the locals are on board with it, because they're the ones that are going to be leaned on heavily for a successful election in the 2024 election. So that is the current status of this procurement, and and that's it.
All right, I appreciate that report. If there is a no-go on this, I think we can possibly discuss that as a legal matter in closed session.
Yes.
For all other inquiries, by all means, we can address that, but I think we have that plan to discuss. All right.
Yep.
Go ahead.
And now we'll go to the Project Management Office. And Keith, would you like to talk about that?
Good afternoon, board members, new board members, and those that transitioned from the previous board. Welcome aboard and look forward to working with you. As all of you should have before you, the report from the Project Management Office. The one thing that I would like to highlight is the efforts that were served working with several of the individuals that have left or are leaving on their transition plans, ensuring that with Jared and those who remain, that we have the knowledge and that we have, everything that we need to continue on the efforts. So there was a lot of things learned, and we'll definitely miss those individuals that have departed or will be departing, and look forward to the new opportunities that are before us. If there are any questions, welcome them.
Thank you.
Thank you. Seeing
And then
none.
the last one is just about the exercise of some of the delegated duties. Since the last administrator's report and last board meeting, I had exercised the following delegated duty, which was to inform the governor's office of what needed to be put in the balance for the Fair Campaign Finance Fund. So pursuant to Election Law Article 15-101, 103F, I determined the balance of the fund as of June 30th, and that it had to be sufficient to provide a full contribution to 2 gubernatorial tickets in the primary and 1 in the general, which is $9 million. The fund was insufficient, and as required, once it is determined that the fund was insufficient, we provide notice to the governor of the amount needed. The amount needed to fully fund the program was less than $650,000. So it was we have been very good in going after the civil penalties for collection and to help boost up the coffers of that fund there. But that's where that was the last bit, and so that was part of the delegated duties that were exercised, just to give the board knowledge of that.
Thank you very much, Jared. And before moving on to the Assistant Attorney General's report, is there a motion? All right, seeing none, moving on to the Assistant Attorney General's report. Dan Colburn.
Good afternoon, members of the board. I'm proud to present an Assistant Attorney General's report at this meeting after, I think, 2 meetings where there wasn't much to report. With this one, the only new matter is the first item on the report, the Gibson v. Frederick County, or Gibson et al. V. Frederick County case. That's currently in an appeal, and I'm going to go a little bit more into this because we have new members who may not be familiar with the litigation. This is a suit in which a private citizen, a voter here in Maryland, or a resident here in Maryland, and 2 plaintiff organizations have sued the state, 23 jurisdictions, including Baltimore County, a nonprofit private organization that is in Chicago, and the Kent County Board of Appeals in federal court, alleging that all of those actors acted in a conspiratorial way under the RICO statutes, which is the organized crime statute, to commit fraud in the 2020 election by taking money from the nonprofit organization and paying ballot mules, or paying people to deposit fraudulent ballots in Maryland's drop boxes. The complaint was filed last year in the summer. It was litigated through the fall. The state, and what's been going on here is that in the trial court, I have been representing the state on behalf of the State Board of Elections. A colleague of mine represents the Office of the State Prosecutor, which is also named as a defendant, and each of the defendant counties have their own counsel. So as you can imagine, there's a lot of defendants and a lot of lawyers in this case. You can see from my report that at the trial level, we won on a motion to dismiss, and the U.S. Federal District Court for the District of Maryland dismissed the complaint back in December. The plaintiffs asked the court to reconsider that dismissal in January. We filed an immediate response. The plaintiff's request was denied back in, I believe it was March, and the plaintiffs immediately appealed the case to the Fourth Circuit, the United States Court of Appeals for the Fourth Circuit. So the case is currently on appeal. The plaintiffs who are now appellants in the Fourth Circuit filed their brief arguing that dismissal was improper about a month ago, a little over a month ago. Forgive me. And now the appellee's brief is due tomorrow. I'm happy to say that an appellee's brief is done. It's actually on my screen in front of me right now. We are filing one brief on behalf of all appellees. All counties have signed on to the same brief. It will be filed tomorrow, and we'll file our response to the U.S. Court of Appeals for the Fourth Circuit. I am hopeful that we'll get a decision, and a favorable decision, in an expedient amount of time, because underlying this whole thing, the requested relief for the case has been the storage or non-destruction of the 2020 election records. And why that's important is that federal law requires a custodian of federal election records to hold on to those records for 22 months following an election. The 2020 election was on November 5th or 4th, 2020. 22 months later was in September of 2022. So the 2020 election records were slated for disposal in September of 2022 pursuant to federal law. Because there is ongoing legislation, all the defendants in Maryland have a duty pursuant to the litigation, not pursuant to federal law, to preserve those records. Because if the plaintiffs win and they get their claim, they're entitled to preservation of those records. They can't be destroyed while the suit is going on. So all the counties in Maryland are currently holding on to their 2020 election records, in addition to the 2022 election records that were obviously generated last November in the 2022 election. And I know at the every election director meeting over the past 6 or 7 months, there have been questions about where is this litigation, what's the state of it? It's becoming a logistical issue. I'm hopeful that we will get a response or a decision from the Fourth Circuit soon, before the end of the calendar year. And if it is favorable, at that point, the plaintiffs in this case will have 90 days to appeal the case to the Supreme Court of the United States. We'll see if that happens. If it does, again, SBE on behalf of the state, me, will be taking the lead in responding and hopefully dealing with it as expeditiously as possible. So the update to this case is that the brief is due tomorrow. It is written and it will be filed tomorrow.
All right, Janet, you're recognized.
Yes, Mr. Coburn, can you tell us the name of this Chicago nonprofit organization that they are?
Of course, the Center for Tech and Civic Life, CTCL.
I figured. Okay. Okay, thank you.
Sure.
Jake?
Thanks, and thanks for that, Mr. Coburn. It's interesting. I'm assuming the ongoing cost for storage is being borne by the counties right now.
I believe that's true. The counties yes.
And then you had mentioned that the suit was 23 counties. Is the 24th Kent and they sued the other entity, or was one county not sued?
So there was actually, it's 23 jurisdictions. So it's 22 counties plus Baltimore City. There were I believe there were two counties that the plaintiffs concede have no part in their allegations. One was, I believe, St. Mary's, and forgive me, I don't recall the other.
Okay, thank you.
All right. Thank you for that, Jake. We are now moving on, and thank you, Jared, and thank you, Dan, for your reports. We're moving on to the approval of final regulations. Jared, are we going to, or members, are we going to take this up as on an individual basis or lump sum?
I think that's up to you. I would think that for the final adoption, we would break it up into two groups here. Melissa is going to do the ones for the election judges and trainings and early voting and the recount batch. And then I was going to do the candidacy and campaign finance ones. Those, we'll be happy to discuss going through it, just to give you, because most of the board members weren't present when they were first proposed. So, but the motion can be to accept them as a block in those two blocks. And then we can then we have another set of proposed regs that you will be going forward. And then finally, the Dropbox regs as well. So I would say you can do it in like 4 batches. So the first batch would be for final adoption of regs with Melissa, and I'll let her explain those 8 that were proposed and adopted.
Okay. Thank you very much, Jared. And Melissa, if you would, for the new members, would you please address those regulations for their, so that they are informed about the movement for approval?
Yeah, absolutely. So there's a memo that is attached to those, and it's number 6 on the agenda. And I guess broadly speaking, all of these regulations were drafted to bring our regs in compliance with new legislation. So we implemented House Bill in these regs, House Bill 1200, which was election judge compensation, and also the training, of election judges. So those are the first, I want to say 2. And then we also added the ability for our local boards to use electronic training material, which is actually the early voting regulations that you see on the list. And that's 4, 5, and 6. And then 3, 7, and 8 were a bit of cleanup, where our regs did not match previously existing laws. We found that out through the process of a special election and cleaned those up after the special election. But I'm happy to answer. That was kind of very broad overview. If anyone has any questions about specific regs, I'm happy to answer them.
Any questions? All right. The chair would like to request a motion to approve. Okay. Is there a second? Is there a second? Second. All those in favor of accepting the first batch of regulations 02, 01, 04 through, I think you said 05? Am I correct?
The regulations in 6, I can list them out. Yep, it's that entire group in 6. So 3301, 0301 to 04, 3302, 03, 05, 3312.0201, 3317, 04, 06, 3317, 05, 03, 3317, 07, 01, 3319, 01, 01, and then finally 3319, 02, 01.
So a motion has been made for approval of the final regulations, properly seconded. All those in favor, raising your hand. So moved. Thank you very much. Those regulations are approved and adopted. Now on to number 7, approval of final CCF regulations.
Yes, so in front of you are 2 regulations, 3313.10.05 and 3313.13.06. The memo, basically, the 3313.10.05 prohibits a contribution from being converted into a loan which is our standard policy, and 3313-1306 allows for fundraising activities exclusively for administrative accounts under permissible uses. Both were proposed and back in May, and we've had no public comment on them, and therefore it's recommended that we proceed with final adoption. So just for the newer members, the first part was codification of a state board policy, of course, and the other one, which was the permissible uses, was just basically a clarification that you couldn't use campaign funds to raise money or to spend money on administrative accounts because it's prohibited to commingle. So this allows them to fundraise for the administrative account with administrative funds only, but you still can never commingle the accounts or try to circumvent and supplement the campaign account funds with admin funds.
Any questions? All right, the chair entertaining a motion.
So moved.
Second.
Properly seconded. All those in favor, please raise your hand. Thank you very much. Thank you. Moving on to number 8. The approval of proposed regulations.
That's
Go ahead.
Oh, sorry to interrupt. For these, I generally give a little bit more explanation since they haven't been approved. Feel free to either cut me off or ask me questions if I don't hit the right balance for you. So these are primarily implementing House Bill 535. Which is the Canvas and Text-to-Cure bill. And so the first one, which is 3311-0306, the legislation requires that the state board provide and each local board provide voters the opportunity to select their preferred method of communication if they need to cure their ballot. And so this regulation now mirrors that requirement. The 3311-0403 is the start of Canvas. And again, this language mirrors House Bill 535 in that it sets the date for early Canvas as 8 days before the first day of early voting. It does allow the state administrator to grant a waiver if the local board meets certain requirements. Again, those are in the statute. And then reconvenes the board after election day. I think, 3311-0504 is also implementing House Bill 535. And so I guess broad picture is that House Bill 535 now requires the local board to count the first ballot from an individual. If they receive 2, they count the first ballot and reject any other ballot. And so we basically spell that out and then spell out several different scenarios more specifically that all have the end result of count the first ballot and reject any other ballot. I think usually I will, do you guys want me to keep going? I switch to a little bit of cleanup after that, but I'm happy to either pause for questions or just keep going.
There's a couple of questions, so thank you, Melissa, for that. Chair recognizes Janet, followed by the Vice Chair.
Yes, the 3311-0504, multiple ballots from the same individual. I don't think this quite matches the legislation. A part of it, the under B1A, count the ballot with the earliest signed oath date. Now, you can sign it, you can send off too, and they won't arrive at the same time or anything like that. I think the legislation was what it says farther on, the first one received, if that's legally sufficient. You may have already, if somebody signs it, whatever, the oath a week before the election, and then 2 days later they do it again, one of them might have already been processed by the time the other arrives. So I think this may have been expanded a little beyond what the original bill says. I don't have it in front of me, but I remember, working on it as an advocate. And you're right, there's a whole lot of possible scenarios here. But I think signed oath date is not really one of the ways to judge if they both have legal signatures. Do you see what I'm saying? This may come up once it's posted for public comment, but that struck me in particular as something that doesn't quite match how it was originally intended.
Melissa, may I jump in?
Yeah, I know we talked about this. Go ahead, Dan.
Okay. You are correct in the sense that this doesn't match perfectly. What's happening here is I have HB 535 open in front of me. The law is going to be Election Law Article 11303.2 effective October 1st. So it will become the law October 1st. It's been signed into law. It will take effect on October 1st. And it says that subject to another provision, if a local board receives more than one ballot from the same individual, the local board shall count the first ballot from the individual that the local board determines is legally sufficient. So, Ms. Millison, what you've pointed out, I believe what you said was the first ballot received. And if the statute actually said the word received, we would have clear guidance on exactly what the legislature meant by first ballot. But what it actually says is count the first ballot from the individual. And first ballot can mean the first one that arrives in the mail, the first one that was sent, the first one that was, there could be a lot of different firsts or interpretation of first. So what I believe the intent was with this regulation was to provide a specific interpretation of that law, to say that the first ballot is the first ballot that essentially can be proved, and that provability is the oath signature and the oath date.
But if they've already gotten one in the mail and processed it, and then you get something that turns out to have been signed earlier, but it wasn't delivered until later, it's not like you can go back and, say this overrides the earlier one. So I'm not sure how you would go about implementing that. I understand what you're saying about the first can be interpreted as an ambiguous term, but anyway, I
think to that point, so there's a couple, in terms of processing, if it has been received by the local board and anything short of canvassed, then that situation can be rectified by the local board. If it's been canvassed, I know that I would have to put my finger on it, but there is another provision in the regs that says if another ballot has been counted, then reject all other ballots. I think it might be in the provisional reg, but that situation is accounted for.
All right, guys. Thank you guys very much. Thank you, Janet. Vice Chair?
Yeah, couple different things. That's exactly where I was going to go. If it's only in the provisional reg, we may need it in the mail-in ballot reg as well, or in this section of canvassing. Because if something is already canvassed, all subsequent received, no matter when, to Janet's point, must be rejected. I mean, because you've already cast a vote. So I was wondering if you guys if the staff could do a check on that to find out where that is and just make sure that whether that needs to be added here or if it's already dealt with sufficiently other places, that would be great. So that was my first thing.
I think it might be in some of the text unchanged portion that we redact when we submit it, but I can certainly look into it and make sure that if it's not there, that we can add it.
That's great. And just like you said, if maybe it's only in provisional, but the provisional canvas is technically different than the mail-in or the absentee canvas. So we'd want to make sure we're clear, unambiguous, that if there is a ballot that has been canvassed already, that all other ballots, no matter how they're received, are rejected. That was number one. Number two, if we could go back to 11.04.03A1, I had two questions there. Because we're continuing to use the word absentee, is that just to remain congruent in how it's called throughout? Are we not going to mail in ballot?
I can answer that one. Sorry.
It's in the Constitution. So, and then there's a law that says it's in the Constitution, but when you're public facing, use mail-in ballot. So all of the laws remain absentee.
So great, and that's what I thought. And then just my last part of my question here, it says the board shall start processing. So this is instructive. Are we meant to be instructive that everyone is starting in all jurisdictions 8 days prior?
Unless they request and receive a waiver, yes. I think that's 2.
Okay, and 2. Okay. I just wanted to make sure that was our intent, because that's what we're saying here is you're going to start 8 days prior.
Right.
Right. Thank you very much, Vice Chair, and Chair recognizes Carlos Ayala.
There. This is going to the beginning of the list for the ballots that are returned without signatures, and having the opportunity to cure those by email, portal, text. Was that something that was coming from the counties, or what was where did the interest get generated for this?
That is from the General Assembly. So House Bill 535 requires text to cure. The other methods of curing have been in the regs and used since before the legislation. So email, things of that nature, but text was not there.
Thank you.
Thank you very much, Melissa. If you could move on to 3315.03.02 and the final Reg 33.16.06.04.
Sure. The 3315.03.02 is actually cleanup. There's a notice provision that was passed with House Bill 410, and when we presented the regs or drafted the regs before, we left out the notification requirement for a municipal council member, and so this adds the requirement that we notify the municipal council member. So now that will match up with House Bill 410. Any questions on that? We're gonna, if not, then we move on to provisional canvas. Okay. 160604 is again marrying up the regs with 535, explaining to the local boards in a bit more detail which ballot to count and which ballot to reject in each situation that they might encounter.
All right. Do I hear any questions?
Yeah.
Vice Chair?
Can you explain, is this is based, this last one, on a law change, or?
Yes, on House Bill 535.
And what did House Bill 535 say, somebody who's voted multiple times provisionally?
It says it does not address if they've voted the multiple times provisionally. It does say count the first provisional ballot, but because we are unable to determine logistically which provisional ballot would be first, the outcome is that both are rejected. If not, we would have a situation where we would have to use some other means to determine which ballot to count during canvass.
Okay, but then if we go on to 2, if more than one provisional ballot is received from the same individual in different provisional ballot applications, all is the brackets added, all ballots shall be rejected. The local board shall, it looks like we've gotten rid of all ballots should be rejected. And instead, we're saying we should count the first provisional ballot cast by the voter.
Right. So if they come in two, sorry, I didn't discuss the envelope portion of it. If they come in 2 separate envelopes, they will have a document on it that has a timestamp. And then we would be able to determine which one was cast first.
Can you think of a reason why someone would cast multiple provisional ballots? And tell me that reason.
Yes. So if somebody's polling place changes and they go to their old polling place, then they would have to vote a provisional ballot. If they then go to their new polling place, then they would also have to vote a provisional ballot. So that would be a situation where it would occur. It's very, very rare, very rare, but it's possible. Or if you add in a mail-in ballot, then it would automatically be a provisional situation. If you went to your old polling place, you would have to vote a provisional ballot. If you went to your correct polling place, you would have to vote a provisional ballot.
Okay. Thank you.
Any other questions regarding those 2 regs?
And just for Mr. Vice Chair's edification, HB 535 does change the provisional ballot law, which is 11303 of the election law article. The election law article used to say if an individual failed to, you reject a local board rejects a ballot if an individual casts more than one ballot in the same election. HB 535 removed that language from the code. So now it is no longer a rejection if there's more than one provisional ballot. So the state board has to step in to kind of organize, like, if there's more than one provisional ballot, now what do you do since it's not an automatic rejection?
I get if I could think, since that was addressed to me, I think it's so rare that I'm not concerned because I think this is unbelievably statistically insignificant. But the idea that somebody would sit down under oath and vote multiple times on purpose is troubling to me. I get the whole thing of I mailed a ballot in, I'm worried about it getting in, so I show up and I got a valid provisional ballot. I get that. A lot of people concerned about the mail. My issue is I've done it provisionally on purpose twice. That's concerning to me.
And I think it probably falls into, oops, sorry, go ahead.
No, go ahead. Please address.
To 2 buckets is, there's always going to be wrongdoers, which I think is what you're getting at. Absolutely. But there's also just a group of voters that have diminished capacity that are very committed to the franchise. And that's really where we see a lot of these situations occur, where you have voters who have sent a mail-in ballot and vote provisionally. They are generally people who are not nefarious by any stretch of the imagination, but just not cognitively able to grasp that what they're doing.
So this is somewhat of a non-punitive corrective action. All right. Jake?
I appreciate that, Mr. Chair. And I was going to say a lot of what Ms. Dorsey said. I think, the House bill, and to put on my old job hat, the Senate bill as well, Senate Bill 279, its intent was to give clarity to the boards should the situation arrive. But as the vice chair said, incredibly rare should these situations occur. But best to be prepared. So appreciate you and your team putting the work into this.
All right, there's no further questions. We will take these on I'll call them out, move for approval of proposed regulations 33.11.03.06, 33.11.04.03, 33.15.03.02, and 33.16.06.04. I'm open to receive a motion to approve on those particular regulations, and holding 3311.05.04 for the board for administration staff to provide clarity beyond the ambiguity of the regulation. So, with all that said, approving. Is there a motion?
I'm sorry, Michael. Which one were you holding? 33?
3311.05.04. Concerns brought forward by Janet and Vice Chair with regards to the level of ambiguity for our clarification on that regulation. Vice Chair?
I would be personally willing to vote for that one, with the caveat that we verify that in other places, whether we needed to come back and add to this to not hold this up, just to verify that we had that if a ballot, if there was one already counted, that all subsequent would be rejected, whether that's added here or already in the code, as long as that we agreed that the staff would address that and bring us something back next meeting. Yes, it's already in the code and here's where it is, or no, it wasn't, and here is a new thing to add. I would be personally, I mean, I don't know, can't speak for everyone, but I'd be willing to vote for that.
I respect that, and I had, there's two members that would, I think, appreciate reviewing how staff addresses that prior to the vote. But I do appreciate you for putting that forward. So we will lump in for approval of the proposed regulations 33.11.03.06, 33.11.04.03, as well as 33.15.03.02 and 33.16.06.04. Is there a motion to approve?
I'd like to make a motion to approve, Mr. Chair.
Is there a second?
I'll second that.
Thank you, Vice Chair. It's been properly second. All those in favor, please signify by raising your hand. Thank you very much. It is so moved. And it is recognized that 33.11.05.04 is on hold for September. All right. Thank you all so very, very much for that robust discussion and clarification and exchange. Now we are moving to number 9 on the agenda, approval of departmental legislative proposal. I would surmise that's Jared taking us there.
Yes. So, but before we jump off of that, I just wanted to, when we were mentioning all the House bills, there was a Senate counterfile as well. There was Senate Bill 379. So on all those there. So it is a bicameral legislative body, and I just wanted to give the Senate some kudos as well as on the passage of that bill, just before everything goes forward there. But this one here is departmental legislation, and we have 3 components into the departmental bill. The first 2 will be addressed by Jen. She's going to explain those, and then I'm going to come back for the candidacy and campaign finance portion of it.
Thank you, Jared. Hi, everybody. Nice to see you. Jennifer McLaughlin here. The first section of our proposed legislation for 2024 addresses information reported to the state administrator. What you'll see is a change to what we would be required to be getting from the clerk of the city court, or basically the administrative offices of the court, to reflect what is the current eligibility of voters. So just by way of background, reporting was established in 2005, slightly modified in 2007. But subsequent to that, ineligibility was modified in 2007. It took out convicted felons are no longer ineligible unless they're currently serving. And in 2016, they took out that does not include parole and probation. So basically, even if you're on parole and probation, you're eligible. And the intent of this this language would be to update interagency reporting 3-504 to match current status of eligibility, which is 3-102, to such that we would get a report that would only be people who are convicted of a felony and currently serving a court-ordered sentence of imprisonment for the conviction. Any questions on that one? Great. The second one involves buildings that the locals use to hold in-person elections. The in-person voting or election day voting standards about how those locations are picked and who has to help us pick those and help us and cooperate are at least 20 years old in code. They're under 10-101A3. And they include the language that you see here: the public official responsible for the use of any public building requested by a local board for an early voting center shall make available to the local board that public building in accordance with 10-101A3, which also outlines all the things, the many hard ways it is to choose a location, accessibility, everything else. The problem is that separately, under the early voting center language, which was established in 2009, references all those other requirements, but does not include the requirement for public building officials to cooperate with us. So we simply are trying to bring the same language that is for election day voting locations and add it to the early voting locations. Anybody have any questions on that?
And by the way, I just want to make note on that one there. That was a Mayo initiative as well. So the local boards that organization is highly supportive of that departmental legislative change.
All right, thank you, Jared. Janet?
Well, Jared may have just made my question unnecessary, because I was looking at the 2022 list of early voting centers, and most, but not all, especially the Eastern Shore, you have a lot of non-public buildings, churches, VFW places, volunteer fire departments. But my question was going to be, did you anticipate any pushback from the counties? But obviously the counties are behind it, so.
Right, and it just gives them more flexibility, because it allows them, if the local board requests it, that then they would have, that they have to be made available to them, in the same sort of fashion that polling places are currently made available to them. So it just gives them another, avenue to get early voting centers. And as you know, early voting centers are a little bit difficult, because you have to block off so many more days than just using it for election day, making sure that it's ADA compatible, and parking, and even public transportation routes, and it being able to service a significant number of the population in that area as well. So having this available to them will be help with the search for early voting centers.
All right, thank you very much for that clarification, and thank you for the question, Janet, to ensure our local boards of election are considered with regards to our legislation. Thank you. And Jared, go ahead. Did you have more?
Sorry, and the last one here is a simple little fix here. So if an incumbent member of a central committee is a candidate for party office, but is currently a treasurer, they can run for re-election. But if you're the chair, it wouldn't allow them under the law technically to run for re-election, because they exercise overall general overall responsibility of the conduct of the central committee. So this fix is just more of a, it was when they first changed it to allow just the treasurer, they should have made it a responsible officer. So it would allow an incumbent chair of the central committee who is running for re-election just to the central committee to still be as a chair of that central committee during that election process. But an incumbent member that's a treasurer or a chair of the central committee may not seek a public office while still being a member of in that position. So this is just kind of a cleanup bill that was just for an oversight to just correct the terminology.
Jake, you're recognized.
Thank you, Mr. Chair. Mr. Marinus, this basically aligns law with reality in terms of chair of a central committee being able to run for re-election to the central committee, a treasurer of the central committee being able to run for re-election to the central committee, but not allowing them to run for public office unless they relinquish that position because they're a controlling officer. Is that right?
Exactly, correct. Right. This is just reality that, you know, these are members there that are just kind of seeking re-election for their own central committee.
Thanks.
Any other questions, comments, concerns? All right. Hearing none, seeing none. Moving, the chair is open for a motion. Jake?
I'd like to move to accept this legislation or move forward. I don't know the exact.
Approval of proposed
Yes.
departmental legislative proposal. Yes.
What the chair said.
Second.
Properly seconded. Thank you all very much. All those approved, please signify by raising your hand. Thank you very much. Appreciate you, Jennifer and Jared, for moving the approval of departmental legislative proposal forward. As well, now moving to number 10, approval of waivers, request Title 13. And I would suppose after that approval, okay, got it. And Jared, that is.
Yep.
On
Yes,
you.
it's gonna be my show for a little bit here now. So the first part here is waiver requests. We denied one waiver. The board has no action on that one denial here. We have in front of you to grant 9 waivers that I present as a block to you with the explanations for it, as well as approval of waiving the late fees for committees that are outside the statute of limitations. And we received a letter from the Office of the State Prosecutor that they're no longer going to pursue any legal enforcement actions against these entities. And the reason why it's outside the statute of limitation is for various reasons that they tried to contact them. They weren't able to find the responsible officers. There was other issues, and over time, it fell outside of it. So this is just basically cleaning up some of the late fees that are outside of it. And this was, I kind of explained it the last time. This is, I think, the last batch of it with the state prosecutor to get all these cases closed from our end and on their end as well. So I present for the board approval the recommendations on the 9 and the waiving of the late fees of outside the statute of limitations on the ones that the state prosecutor will no longer pursue.
All right. Thank you very much, Jared. Any questions? All those, the chair is open to a motion for approval of waiver request. Thank you very much. It has been moved. Is there a second? It has been seconded by. Is there a verbal
The vice chair. The vice chair.
It has been
You got
properly
me.
moved and seconded by the vice chair. Thank you very much. All those in favor, present by raising your hand. Thank you very much. And it is so moved and approved. Thank you very much, Jared. On to number 11, approval of waiver request, Title 14.
So again, this is a little bit different. Remember, as I explained, Title 14 are entities that have government contracts of $200,000 or more, or the other portion of the contribution disclosure statement is that you employ a lobbyist of $500 or more, and you have to report all your contributions. In front of you is a waiver request for 3 entities that met for good cause, and we have denied 6 entities. There is no action of the board on the denials, but we recommend the 3 for board approval. And if there's any questions on the 3, I'll be happy to answer those.
Jake?
Thank you, Mr. Chair. Mr. Demaris, and I'm trying to pull it up right now, but I noticed when I was reviewing them this weekend, in one of the rejection of waivers, which I know we don't have a vote on, there was a concern by one of the parties raised that this was this being an annual report was a new thing, or they were unaware of it. Is this a new? I don't recall this being a new requirement, but I wanted just to check with you.
So it is not. One of the it is Title 14 and the filing of on the ethics portion. Title 14 has been around since I think in the 1970s, and the ethics portion of it has been around since 2000. There has been changes subsequently. The mandating of it was I think changed for with the Campaign Finance Reform Act of 2013 for Title 14 filers, that they had to file all the time. And then I think 2 years ago we did it with the ethics filers as well. So, and the ethics filers have lobbyists. So, and we work tightly with ethics. So, we've informed them. It's even though it might be more of a newer requirement, the basis of the law has been there for a long period of time there, as well as as much as information out. So it's not necessarily, some of them are a little caught off guard, but that's why you pay attorneys and lobbyists to be a part of that.
Yeah, appreciate it.
Thanks.
All right. Any other questions? Sorry. All right. All those, is there a motion to approve?
Motion to approve.
Is there
Seconded.
It has been moved and properly second. All those in favor, please show by raising your hand. It is unanimous. Thank you very much. Your Title 14 waiver requests are approved. Moving on to approval of confidentiality requests, and that's Jared.
So in front of you, you have 3 individuals for confidential voter status, and they have been verified to meet the criteria of the confidential voter requests.
All right, any discussion or question? Hearing none, see none. Is there a motion?
So moved.
Second? It's been moved and properly seconded. All those in favor of approving Title 14, please confidentiality request, please show by raising your hands. Thank you all very much. It has been approved. All right. I just wanted to also thank everyone for their due diligence and commitment and focus. As we move on to old business, there are 2 bullets for old business, and for the sake of time, I'd like to use the chair's discretion to discuss approval of State Board of Election bylaws to September. Yep, Jake, go ahead.
I'd like to move that we move that discussion until September.
Is there a second?
Seconded.
Thank you so very much. It's been properly seconded. All those in favor, please show by raising your hands. Properly moved. All right. That's for B or both matters, Jake? I'm sorry. I think
that was for B. That was
B,
for the filers, yes.
And I would like to have a discussion on Regulation 33110104. That is a holdover from previous board meetings dealing with firearms and ballot boxes. is there any comment? Yes, Janet.
Yeah, I have an amended version of that to propose that adds one word and slightly rearranges it so the modifier's in the right place. Because I remember previously, Sky Woodward, a former member of this board, and some others were concerned. What if someone drives up to a ballot box and it's within the no electioneering zone and they have a legal firearm, say, in their car? Are they violating, are they violating this law? So what I'd like to propose is changing it to the following. Except as provided in section F2 of this regulation, an individual shall not brandish, carry, or visibly possess a firearm within the electioneering boundaries set forth in section D of this regulation. In other words, simple possession won't be penalized. If somebody drives up and has a legal firearm stored out of sight in their car's glove box or trunk, that wouldn't be a violation, because we're saying you cannot visibly possess it. I mean, you still couldn't have it, waving it around. Brandish and carry are still in there, but it's not possession per se being penalized. It's being visible. And I'd like to hear the thoughts of my fellow board members on this proposed change.
Chair recognizes Vice Chair and then Jake.
I love the direction you're going, actually, Janet. I am a little concerned because the word carry may be an instrument of law. Maybe the illustrious Dan Corbin Codrin can speak into that. But because there's concealed carry and open carry, how is the word carry understood? I have no problem with the word you can't brandish and you can't visibly, carry. But you had, I think, proposed brandish, carry, or visibly possess. I'm worried about that one word carry because of its use in law currently.
Okay.
I guess that was I guess the Vice Chair was directing Dan or asking Dan for clarification with regards to, I guess, constitutional language in regards to being armed or having weapons during a visiting a poll.
Right. So to address the specific question, I'm going to have to reach back here a little bit into my prior life. But when most of the time the prosecution is for possession is the expansive word. You can have actual possession. You can have constructive possession. Carry usually denotes physical possession on or about the person. So I don't think, although I would want to confirm this because I haven't done this research in a couple of years, but having a legal firearm in the vehicle in, say, a glove compartment is not necessarily carrying that vehicle. Carrying is usually physical possession on the person. But I know there is case law on it. I actually remember reading case law on it for some cases that I had worked on previously. So your concern is a valid one about the definition of carry. I guess my question for the board here is, putting the wording aside for a second, I think that what is productive is, what does the board want to stop and what does the board want to allow? And then we can tailor the words around that.
Well, I believe the provision or the regulation essentially wants to stop any threat or imminent threat, and also the free access and exercise of our citizens' right to vote in a safe environment, which is also already guaranteed to each and every citizen via the Constitution. So that it also conveys over to the drop box. So I think ultimately no one wants their constitutional right infringed upon. and understanding how there are some gray lines here. I don't think any of us are hoping to create opportunities for stop and frisk because I think we've already, I think all of us are in agreement that that is bad policy and bad practice that has been displayed throughout our nation and some of our major cities. So we do not wish to invoke that throughout for every one of our citizens in the free exercise of their civic duty. So with that being said, I think that is our focus, Dan. I understand the conceal and carry, but I also recognize that those who have the ability for conceal and carry are those who are affirmed law-abiding citizens in order for that privilege to be met. So I don't want to speak on their behalf beyond what they already know and carry true to their obligation to have the privilege. So I'm pretty aware that they're just as aware as we are with regards to their obligation and ensuring the freedom of all of those constitutional rights, be they the right to vote and the right to bear arms. So with that being said, Dan, if we could clarify that that carry language, and I don't want to divert from what Janet's provision is providing or recommendations providing. I think it provides a tremendous amount of clarity for us to move forward. I'd like to, if it is offering that up as a amendment, or if there is a motion to consider that as part of the language, with the hope to clarifying the language carrying.
Yeah, so moved.
Is there a second?
So move what?
Janet's recommendation. Go ahead, Carlos.
Sorry, to adopt Janet's language with regards to adding in visibly possess after brandishing.
Is there a second?
But are we eliminating the word carry?
Not yet. We're voting on the language. We're voting on the language. There has been a motion. Is there a second?
Mr. Chair, I'd like to move to second, but I'd like a little bit more discussion before we vote.
That's fine.
Yeah.
Is there more discussion on what
I'd like to understand exactly what the wording is in the motion, please.
Okay. The part that changes is an individual shall not brandish, carry, or visibly possess a firearm. And before, I think it was carry, brandish, or the order before was possess, carry, or brandish. So I just put the word visibly in front of possess and just grammatically rearranged it. But I understand the point, the question being raised. Maybe we do need to look a little more into the meaning of the legal meaning of carry and possess. But again, I'm adding the one word, shall not brandish, carry, or visibly possess a firearm. And as I say, if it's locked in the trunk or the glove box and you pull up to the drop box to drop off your ballot, you're not violating anything.
Well, to that point, I do have a question for Dan. If one is able to brandish, they are carrying, correct?
If they brandish, they are carrying. Is that what you've asked?
Yes.
Yes, all brandishing is a carrying.
So that's implied, correct?
Subset. Okay.
Yes.
So,
yes.
So if that is implied in brandishing, what is the difference of? So the difference of putting the word carry explicitly in there, I guess it lends into the conceal.
Not necessarily. So
okay.
Brandish is to display in an aggressive or in a displaying manner. You're taking the item. I'm not going to use my hand. I'm going to use my phone as an example. If I can brandish the phone by specifically holding it up to the camera, so for the purpose of having you see it, that's brandish. Carry is I happen to be holding it while I'm on the camera. I'm carrying it and you can see it, but my purpose is not specifically for you to see it. So brandish is the most aggressive behavior. Carry is a less aggressive behavior that may have the same result or outcome.
Okay. Thank you. Jake?
So this is my concern a little bit, and went back and looked at the state legislation. The state law is obviously a lot more vague. It's just talking about a location that's currently being used as a polling place. But my concern is that a person can carry a weapon in a way that is not brandishing, but that can also make people feel unsafe or feel that their right to the franchise is being threatened. Right? If somebody is, I'm going to use a absurd example just because it makes it, I think, a little bit visually easier, and please forgive me. Somebody is walking around a parking lot of a polling place with a shotgun strapped to their back and a sign for a candidate, doesn't matter who the candidate is, voters can feel threatened by that, but that would not be brandishing. That would be carrying. Isn't that correct, Dan?
Yes.
So that's my concern in that regard. And I'm open to this. This is not me saying, no, but this is where I'd really like to get some clarification before we move forward, because the line between brandishing and carrying is, very, very thin in terms of the impact it could have on people.
Vice Chair?
I would feel comfortable or more comfortable with language like shall not brandish or open carry or visibly carry. So my concern again is the weaponizing of something. So you have somebody comes up who has a concealed carry permit. They're not even thinking about it. They pull right up to it. They hop out. And I want to remind everybody, while we are in the act of voting, when we approach the drop box, I've yet to see a person fill out their ballot on the top of the drop box and put it in. They're transporting. We're protecting this by this 50 feet or 20 feet, whatever it is. No one's looking over their shoulder. There's no camera on them actually filling out their ballot. We're providing them free and easy access. And we have somebody who has a concealed carry. They pull up. They're not even thinking, but they're concealed carrying. They hop out. They throw it in. They have not broken the law by doing that. So, I would feel comfortable with brandish or visibly carry or something like that, or open carry, whatever the Assistant Attorney General would tell us that art of law would be there for open carrying or something like that.
Yeah, I think, Mr. Chair, like what the Vice Chair is describing, I think comes a lot closer to kind of avoiding the potential chilling effect that I think the legislature was trying to avoid in that regard.
All right, thank you for that. Janet?
Yep. Dan, however, was saying carry usually means physical possession. If somebody drives up and they have a firearm lying on the front seat of the car, I think we should, my point being, we shouldn't get rid of possess. And I mean, carry applies to, it's on you, but if you're driving up, you hop out of the car and somebody walks by and sees, a firearm lying on your front seat, I could see them feeling potentially threatened by that. So I guess what I'm saying is let's leave the word possess in there and not assume that brandish and carry cover all circumstances. But that's all.
Yeah.
All right, Vice Chair.
I would still have a problem with the word possess because of its many meanings. And I'll give you another. Hunters keep shotguns, in racks, often unloaded, but there's a firearm, in a rack in the back of there. It's a shotgun, which is legal, and they're on the way to duck hunting in the morning and they're stopping in to drop off their thing, and they have 2 shotguns on the rack in their back window of their pickup truck. Not a hunter myself, but I've seen that often. They would technically be breaking the law. So I would be comfortable with brandish or open carry or visibly carry.
Okay.
All right, we have a few things on the table to consider. Janet, that was being met, I guess, recommended as part of your recommendation. It had been moved by board member Ayala. Yes, go ahead.
Mr. Chair, can I withdraw my motion?
Not a problem. Totally understand. There needs to be further discussion, and duly recognize and appreciate your understanding and your leadership in moving us forward with more discussion. Because I do think Vice Chair's recommendation or request of council to help more clearly define the terms that are being utilized with regards to carry and or display or possession. I think we need to get more granular and less ambiguous with regards to our regulative responsibilities to the legislation. All right. And can we, okay, go ahead, Jake.
Mr. Chair, I mean, it sounds like we have several proposals that are worthwhile to discuss. Would it be improper to just motion that we move this to September, but ask Mr. Coburn to come back with answers to some of these questions about the definitions of carry and brandish? So hopefully in September we can make a final decision here. And I see Mr. Demarinis.
Thank you, Jake. Jarrett?
Yes, so I just wanted to make note here that basically what the board is really arguing or debating over, is point 4F, which is the other activities about the firearms there. But if the board can look at or at least approve that we can start the process on point 4D and E about election nearing boundaries and activities there, those are not described with the gun debate currently. But at least then we can start moving forward with those regs, because the electioneering boundaries were of an issue in the 2022 election with drop boxes extending the boundaries beyond the 100-foot area. In some places, it was extending it to almost 200 feet. This would make it, the electioneering zone as 50 feet. And then also, if on election day, if the drop box is within the election boundary of the polling place, it would just make it clear that the line for the electioneering zone is the line for the ballot box shall be of the polling place. So, those I think need to be at least addressed at that point here to move forward, so that the campaigns can then kind of either comment on it or make sure that they're involved for the May election as well.
Jake?
Yeah, Mr. Chair, I think that makes sense. I'd like to move that we approve 331101.04 D and E, but hold on to F for the next board.
Vice Chair?
I would like to ask the staff if they would potentially accept a friendly amendment to their proposal on .4E2B. If we could add the word observing or recording voter activities by a group of affiliated individuals. My concern there is if you had, they're allowing one individual to come in to observe election activities to make sure there's no malfeasance, but not a group of individuals. But what if there were three individuals who were unaffiliated with each other, didn't know each other from Adam, from 2 or 3 different news organizations maybe, they would technically be violating this. So I think that's the spirit of what the staff had put forward. But I'd hate to see that again, unintendedly enforced in that manner.
With that being said, he's requesting an amendment to the regulation that may impact and affect the whole for a vote on the regulation itself. So with that being said, I would like to, since this is an old business, it is not being sought for approval and or vote at this time, is that the regulation be updated per the vice chair's request and then brought for the board for approval, not necessarily striking 3311.01.04, but having for September old business. Yes, Jake?
I'd like to modify my motion. So let's strike that one because I think we can at least move forward with 331101.04D, which is the electioneering boundary, and at least give the board staff the ability to start working on that while we look at the vice chair's suggested change for E and the discussion on F. So, Mr. Chair, I'd like to move 331101.04D for approval.
It has been moved and properly seconded. All of those in favor, please raise your hand. Thank you very much. With that being done, I appreciate that guys working through that with us effectively and efficiently as possible. With that being said and done, we are on to number 14, new business. Being none, are there any, and to that point, with regards to new business, we've had some very robust discussion. Going forward, each and every one of us, if you don't mind, please send in any new business or topics for discussion to the board, to Jared, for us to have as part of the agenda prior to, it's totally fine to introduce new business the day of, but we would like to streamline the effectiveness of our discussion as we are present. So if we could send that in to the board so that all board members prior to the meeting will have or be aware of the new business being presented and time for preparation. With that being said, it is a recommendation from the chair. That's what it is. So with that, number 15, disclosure of campaign contributions. Are there any disclosures at this time? All right, seeing none, thank you very much. The next meeting should be set for September 28th. Does that work for everyone at this time at 1:00?
Why not 2:00, like it says I think it says in the bylaws, doesn't it?
Yeah, I think there's some ambiguity. There's some flexibility. I think we've been flexible with regards to dates in and of themselves. So if we could.
Mr. Chair, I'd like to suggest that we do 1 instead of 2. It gives us a little bit more time in case,
What was the date again? I'm sorry.
September 28th.
Okay.
All right. So we are meeting. We have set the date, next scheduled meeting for September 28th at 1 p.m. Thank you. Thank you also very much for being amenable to that. And now we, yes, Jared.
Mr. Chair, I just want to, because we were thinking about scheduling the December one in person. I just wanted to make sure that it's on everyone's calendar because usually the November and December ones kind of get combined. And I just also want to give the staff notice to come to that one as well, to introduce themselves to the board members. So it doesn't have to be discussed at this one here, but I just wanted to put that, at the September one, I would like to plan for, if we could, plan the December meeting with everyone's calendar, because that one was scheduled to be an in-person board meeting. So.
All right, thank you very much. Very much, Jared.
Thanks.
Now, with that being said, we have closed meeting to discuss two topics with council. And we are moving in at this time into our closed session. And go ahead, Jake.
Yeah, I'm sorry, Mr. Chair. Do we expect to come back to open session afterwards, or are we going to?
Yes, I was going to address that. We will be back following the closed session to adjourn publicly. All right. We're going to take about 5 minutes. Is everybody okay with five? What do they need? 5-10 minutes. I think we're we got about 10 for bathroom break. Would you say 10 minutes? I think we're looking good right now. We're going at a good clip. All right. So 10 minutes from now, 2:58. Oh, let's just say 3 o'clock. All right, guys, back at 3 for a closed session.
So Jared, just so you know, normally somebody from the staff end would send that script that the chair can read.
Gotcha. I apologize.
We don't have to come back into open session if we have no more business to do. Isn't that correct?
That is correct.
Yeah. So we can say we're not coming back, just like we've always done. We have to vote to go to closed session, but then we're formally adjourning. It will automatically be adjourned completely for any business for the open session.
Well, I thought there was a plan to give farewell testimonials to Linda Lamone. But
Well, I just wanted, before everyone, we're still Zooming here. So just, so if you want to.
So there is the intent to come back for adjournment in the public open meeting. All right. But with that being said, we are moving into a closed session for the matter involving or seeking legal advice for two matters. One being in regards to the poll book, and another with regards to seeking advice of counsel for pending or potential litigation. All right, and part of the meeting may be closed in accordance with the Open Meetings Act procedures. And that is what we're seeking at this time. And we will return following the adjournment of the closed meeting.
So moved.
Is there a second?
Second.
Thank you very much. All of those in favor? Thank you. It has been moved that we are going into closed session. Are we back on? All right, great. Thank you very much, guys, for coming back after closed session. We are moving to adjourn, but prior to that, I wanted to offer up the opportunity for the members to provide any salutation or public comment in recognition of our retired or Linda Lamone's retirement as state administrator. The floor is now open for that as a possibility. I recognize Janet and then Vice Chair to close. Janet. I think you're on mute.
Yeah.
Okay.
I'm going to have to apostrophize here because Linda is not here herself. I would say she richly deserves all the accolades and awards she's received both locally and nationally. Her deep knowledge and dedicated advocacy have created an electoral system we can all be proud of and made Maryland a role model for other states. She's built a strong, resilient foundation on which the State Board of Elections can handle whatever the future brings, although hopefully we'll never see a repeat of 2020. So I think we really need to thank her for all she's done.
Sure. So, thank you, Mr. Chair. If I could, I'm not going to try to wax eloquent too long. I am a pastor. I have this tendency to drone on. I'll try not to do that. I would like to add not only for Linda, which I'd like to finish with, and I know Donna's with us for a little longer, but I'd like to say about Donna and Nikki, having worked with all of them, both Donna, Nikki, and Linda extensively over the last 5 years. And before that, less extensively when I was at the local boards, I have found them all. I mean, Donna was so awesome, was always provided anything I needed faster than I thought it should have been provided or could have been provided. She's just so easy to work with and so even-keeled in her temperament. And Nikki was the motor vehicles has gotten a real coup there to get somebody as qualified and organized and is just huge, high aptitude, high efficiency, high performance administrator in Nikki Charleston. I think a lot of her and what she does. And working with Linda, for 5 years, I found her to be unflappable and steady. And we worked together through COVID with all three, but especially, with Linda's leadership through COVID and difficult times, making difficult decisions. And then as chair with her for a number of years, working with her and Nikki closely, particularly Linda, and just trying to understand what was in front of us and try to navigate through that. I found her to be unbelievably steady. The work that she has done as the first and only administrator until Monday, whatever the first is, until we have Jared, who's an unbelievably capable second administrator. But she basically created what we have in Maryland in a statewide system, and I'm humbled to have worked with her, and I'm a better person for being on the board and for working with Linda Lamone. And I'm sad that she's not here, that I can tell her that directly. So, just not sure what else to add. She's fantastic at what she did for so many years. She deserves a great retirement. Thank you.
Jake.
Thank you, Mr. Chair, and God knows I'm not going to try to wax more eloquently than somebody who does it in front of a congregation every week. First, I do want to echo what the Vice Chair said. Donna is somebody who I've gotten to work with a lot over the years, and Donna is, and I've seen it just as much on this board, someone who is always behind the scenes and doing the work and making the trains run on time. And Nikki Charleston has just been, sorry, my child is getting impatient with me. Nikki has been the paragon of professionalism And I do want to shout out, Jared mentioned at the beginning, Tyler Carr coming on board. Down to 60. And I am super excited about that. I do just want to say this. There will never be another Linda Lamone. And I say that with all the excitement I have for Jared taking over this role on Friday. But you speak to national experts, local experts, people who have worked in campaigns for decades, elected officials, and I've gotten to work with some of the greatest, and they all have tremendous respect for her and her work. And God knows the amount of times people have written articles or talked about the end of Linda Lamone, and people have counted her out time and time again. But she always stared down those challenges and proved her doubters wrong in some of the biggest stages that we've had in this state, as well as in the halls of Congress. And her passion, her dedication, her belief in the mission of fair and free elections can't be overstated. And I always hate doing these things because it feels like the person's dead. And God knows Linda is not. She's not done. She's, I know, continuing her work with the Attorney Grievance Commission. As an attorney, it's one more reason I want to make sure never to appear before the Attorney Grievance Commission, because having to stare Linda down is a terrifying thing. She is unflappable. She is professional. She can spin a yarn as good as anybody. And she's been a really tremendous leader for the state, and just want to publicly thank her for her 25 years of leadership.
Thank you all so very, very, very much. The words and sentiments were extremely fitting. I would have felt remiss to not capture the historical significance in this recorded moment if we had not done so. So thank you all so very, very much for your commitment to your mission and your due diligence in getting through this very robust agenda. Great job, guys. Thank you so very, very much. More to come. If there's nothing further, is there a motion to? Yes, Vice Chair. We can't hear you. We can't hear you.
Oh, sorry. And it was so important because I moved to adjourn.
Oh, is there a second?
Second.
Been moved and properly second for adjournment. Thank you all very much. All in favor? Raise your hands. All right, we are adjourned. Have a good evening.